Good evening, everyone, and thank you for coming and attending our Keeping the Bench and Bar Together event today. One of our COVID special meetings that replaces some of the in-person events that we all used to know and enjoy, where we got to talk to the members of our local bench and keep connected. So I hope that you all enjoy getting to talk to Judge Jamo a little bit today. I think that what we're going to do is I'll have a little bit of an introduction here, and then I'll have a couple questions for Judge Jamo, and then we're going to open up the floor. So you can either ask a question in the chat box. I'm going to keep my eye on it. Also, feel free. I believe that we have the raise your hand function, and you can also just kind of talk up. Judge Jamo and I discussed it earlier, and I think we're just going to try keeping this nice and casual. So feel free to hop in. Don't let me get in your way. So again, thank you, everyone. Thank you, Judge Jamo, for attending. For those of you that don't know Judge Jamo, he, of course, is one of our 30th Circuit Court judges in Ingham County here. He was first elected in 2012, re-elected in 2018, and his current term ends in 2025. Prior to becoming a judge, Judge Jamo worked in the private sector for about 28 years. And because I know that none of you came here to hear me listen and talk tonight, I'm going to turn over to Judge Jamo. And Judge, I was wondering if you could introduce yourself a little bit to us and tell us a little bit about your background.
All right, well, thanks for having me, and thanks everybody for joining. I was saying to Alex when we were talking about what should we talk about on this, we were hoping people will ask questions. But one of the things I said to Alex is that when he gets to the softball question of tell me about your background, I always feel like my background is not very interesting. I'm always interested in other people's background. That everyone else's life always sounds so much more interesting to me. But I'll give you a little bit of personal background and also legal background to the extent that you may be interested in it. I grew up as a kid in Detroit, in the city proper, where my dad was a mailman, city of Detroit mailman. And I lived in Detroit until I was 13, at which point my dad switched from being a mailman to, he went into law enforcement, actually. He became a postal inspector, so he was a federal agent, which at the time, if you came out of the mail service, out of the post office, you became a postal inspector from within. They wouldn't let you stay in the same state that you worked as a postal person in. And so he got transferred to New York, to Brooklyn, New York. And we moved to New York for a few years. And then eventually moved back to Michigan after a few years because both sides of my family, my mom's parents and my dad's parents both lived in Detroit. So we moved back to Michigan. So I spent a lot of time in Detroit proper. I've been thinking about that a lot lately because of a lot of the social issues that are going on. I lived in Detroit during the riots, what some folks are calling the rebellion or uprising, but at that time we called it the riots in '67, and also was there during the Tigers' heyday in '68 for the World Series. So that's my background as a childhood background, essentially. Fast forwarding to college, I graduated from U of M and then went to Cooley Law School. While I was at Cooley, I spent 2 years, pretty much about 2 years of the 3-year stint there, working as an intern at the Prosecuting Attorneys Association of Michigan, where my assignment was to review case law and write case summaries for what at that time, I don't know, I've never asked the prosecutors, we have a couple of them on. here, I don't know if they still have this, but at the time was a big binder. It's probably on computer now, but was a big 3-ring binder of case summaries. That was the trial case summary book that you, as a prosecutor, you could get from the Prosecuting Attorneys Association of Michigan. I'll back up just a little bit. During college, I did a stint in the summertime working at a Ford factory, and I also did a couple of summers driving a Coca-Cola truck in Pontiac. And so anyway, then in law school, as I said, I worked at PAM, and then took the bar in July of my last year of law school. So I took the bar before I graduated from law school. I don't know whether you can still do that. You could at that time. And then got my bar results in November, shortly after I had graduated, and joined a small firm in Lansing called Denfield, Timmer and Taylor. We were kind of known as, a lot of people referred to us as a boutique law firm. I was never quite sure what that meant. I guess maybe it meant we were a little bit unusual, either, I guess, from the perspective of our size, given the type of clientele we had. But basically, we were a litigation firm, primarily civil litigation firm. And I had clerked for them during the summer last year of law school with the intention that I was being hired to be an associate attorney as soon as I got my license. So I worked there that summer and then became a lawyer in November and of '84, and then worked there in that firm. Really, I was only in 2 law firms. I really only left that law firm because one of the senior partners that I started with, George Denfield, retired. Another one was going to retire soon, Jim Timmer, who was a terrific guy. Both those guys were really great mentors to me. And the third named partner from when I joined, Cliff Taylor, had since gone to the bench, initially appointed the Court of Appeals and then the Supreme Court. So that when the other partners were getting ready to retire, then I shifted law firms and eventually became Gura, Jamo and Young, and then went on the bench after being there for several years. So I was a civil litigator for about 28 years before taking the bench. And that's kind of my background, Alex.
Oh, thank you, Judge. I appreciate it. And I was wondering, after you had the career being a civil litigator, being in the private sector for so long, how did you make the decision to, enter public life and run for judge?
Well, sort of kicking and screaming. I had earlier in my career, I had some people who had encouraged me to run for judge. And I said, no, I'm not going to do that. I'm not interested in running a campaign. I'm not really somebody who wants to be out front in that way. And so I just sort of put that out of my mind, even though I was a couple of times asked about it, and just ignored those inquiries and kept practicing law. And eventually I got asked again whether I would be interested, and sort of actually have been encouraged by my wife to consider it more strongly than I had before. And some other folks then approached me and I said, okay, I'll consider it. And that's how it eventually happened. But I am, in my mind, sort of the last person who was interested in running a campaign. I found it interesting, learned a lot. I think it was a good experience, but I'm typically not the one who wants to be at the front of the room. Now I am every time I enter the courtroom, I guess.
Can't avoid it now.
Right, exactly.
Oh, Thank you. Judge, you're coming up on about 10 years on the bench now. I was wondering, what are your guiding principles as a jurist, and how have those evolved over time?
Well, I'm not sure they have evolved a lot. I sort of came into the doing this work, given the background that I had some pretty definite ideas of from the experience I had. I had a pretty diverse litigation background, including diverse geographically. I mean, I counted one time, I forget how many counties it was. A lot of different counties in this state that I practiced in the circuit courts. I practiced in the federal courts. And so I'd seen a lot of judges. I had a pretty good sense of what I thought was good and not good about judges. And so coming into it, I kind of had some ideas about the way that I would approach it. And one of the approaches I have is sort of like the medical field, the saying, do no harm. I try not to do any damage unnecessarily to anybody's case. Last week, actually, this came up because I had some lawyers in for a hearing, and near the end of the hearing, I typically, as some of you may know, I sort of ask whether while we're all together, there's anything else we should talk about. And so one of the lawyers sort of reluctantly, it seemed, said, well, the opposing counsel and I have been talking about a couple of things. We're sort of looking down the road about what may come up in this case and how we want to approach it. And so we were thinking about approaching you about some ideas we had and how maybe we could work on the schedule to accommodate those ideas. But I've never been in front of you. And so I really, kind of wondering about your philosophy and your approach to, changing dates or working with the lawyers about things that we are having trouble with. And I said, he said, so I don't know what your philosophy is. Maybe you can tell me your philosophy from the bench and we can see if we can approach you about these issues. I said, well, my philosophy is really pretty simple. Your job's hard enough without me making it harder. So if I don't want to unnecessarily make things more complicated for you. So let me know what the issues are and I'll try to work through them with you in a way that I don't get in your way if it's possible. You've got clients to represent and things you need to do to get that accomplished. And you don't need me as a roadblock to that if there's a way I can avoid it. Obviously, there's some things I have to do to keep cases moving and things like that. And obviously I have to make rulings that one side or the other maybe aren't going to be happy with, but if I can avoid unnecessarily getting in your way, I'll do that. And so that's kind of the approach I've had, Alex, to working from the bench. Sometimes that's, it's unavoidable and we cause some upset, I suppose, to some lawyers or do things that they're not happy with. But otherwise, I try to avoid that if I can avoid doing it.
I appreciate that, Judge. And I probably can talk for everyone on this call. We've all experienced the opposite in one form or another, and certainly appreciate it. And that kind of gets me into my next question. Just from looking at all the different faces on Zoom here, I can see that we have prosecutors, defense attorneys, on both sides of the civil arena. And we also have attorneys that are newer and more experienced. And I was wondering if you could just kind of share with us as a group some of your tips maybe in general, and then specifically in your courtroom, on how to be our best?
Well, I suppose one thing is, which you've heard, I'm sure, from many other judges, is to make sure that I have whatever your pleadings are that you're going to be talking about, your briefs. It has become a little bit complicated in the era we're in, between not being on site personally a lot. Lawyers aren't just in the building all the time. And so where you might have been down here because you're going to be here for a hearing on, such as on a certain date, and you decide, well, I'm going to drop off the judge's copy of the brief for another case while I'm down there. There's less of that just because you're around the building less. And sometimes we've even been fairly shut down, as we are right now, in terms of the public coming in, but making sure that I have your pleadings and your briefs, because I do read them, as most of you know. I do make sure that I read through everything before you show up for a hearing. So that's important. And one of the things that has happened, we've all experienced the mail delays that seem to have gotten worse over the last couple of years. And so I have a lot of hearings where lawyers assume because they had mailed things that they actually got there. And that's not always the case. So it's probably good to check and make sure that that I have everything. We have also, I'm afraid, unintentionally confused some folks with the way the clerk's office is receiving pleadings. Because of the COVID rules that we operate under, you can email to the clerk's office, but the confusion seems to come from the fact that we're not an e-filing court. Someday we will be. We're rather low on the list in terms of the timing across the state as to when we will become an e-filing court. But that means that the court rule that would eliminate providing judges copies of briefs doesn't apply. I mean, what applies is that you do have to provide a judge's copy. So that's been a bit of a problem, and so something to keep in mind, because I do have more hearings than I would like, or that the lawyers would prefer, where they show up and realize that I didn't actually receive their brief, their reply brief, or their response brief. We usually try to get in front of that and make calls and say, do you realize that we don't have your brief? But sometimes that doesn't happen, or I don't realize it until, depending on what else I have going on during the week. If I'm only reviewing your brief the day before your hearing, I try to do it a little more in advance than that, but sometimes that doesn't happen, and I don't realize until the last minute that we didn't receive your brief. So something to keep in mind, because it's important to me that I have it, and it's important to you.
With COVID-19 and all the shutdowns, Judge, and I guess also just with problems with the post office over the last several months, have you seen significant problems with some of our rather short filing deadlines?
Yeah, I think it's a real, I think it's a real problem. I think going forward that we need to give some consideration to that in terms of what the court rules require now. The court rules are totally inadequate in time frame in terms of mailing of things, given the time, that the exchange time. That can be, some of that can be eliminated, of course, by the agreement to exchange by email, that the parties can agree to do that, and it will be eliminated to a large extent once we have e-filing. If any of you are, have a federal practice and are used to dealing with the federal court system, once something's filed, you can get on as an attorney of record. You can get on and you can look at it. So if somebody mailed you something and you're not going to get it for 7 days. Even if they didn't email it to you, you can see it immediately on the court website. And eventually that's how it'll be here. And eventually the reason for the elimination for e-filing in the court rules, the elimination of the judge's copy, is because we would then be able to immediately see them. Now our pleadings do get scanned, but the timing of getting them scanned is such that sometimes they're not in the system that I can look at in time for the hearing even. And particularly in COVID, where we have some issues with staffing of the clerk's office and so forth. So yes, I do see that as a big problem and something that really should be addressed in the court rules. But again, if lawyers are working together, they can help eliminate some of that too.
If I remember correctly, I think Judge Schlegel in Clinton County is now requiring motions be filed 14 days before the hearing. I was wondering if anyone in Ingham County has thought about those kind of requirements with everything we have going on.
I haven't seen that, but that's I'm glad to hear that. I didn't know that about Judge Schlegel. I might ask her about that as to how that is working for her up there. But it's a good idea to try to build in some of that. So the problem, again, if lawyers are working together, it sometimes can eliminate some of this, but obviously there's some cases where that doesn't happen as well as everybody would hope. But the problem with that is that if the information isn't being conveyed either to the court or between the lawyers, it makes for a less effective hearing for both sides. And so, if the objective is to have the best outcome possible for your clients, it only makes sense that everybody is communicating and that information gets exchanged timely.
And I just had to look up the court rule, but 2.107 allows for a stipulation between the parties for electronic service. Has that become standard practice in your opinion, or is it still being used very little?
Yeah, it's not as standard as you might imagine. I thought by now that would be more of a regular practice. I mean, I see it, but I don't see it on every case. And so I'm not even sure it's the majority of the cases that I see it on. So it could be used more and probably should be used more. It's a helpful tool.
And Judge, we just got a question from Mary Chartier, and she says, that's interesting, but can a judge make a court rule more restrictive for the parties?
Well, Mary, that'll be something that you research and bring a motion on. I'm not going to answer that. There are some rules that judges can make in terms of just operating their own docket. So I'm not sure what form Judge Schlegel has that in. So that's something I want to ask her about. For example, just based on scheduling, we make statements in our pretrial orders or scheduling orders about when we recommend in terms of timing of when you contact my office to get for example, a summary disposition hearing scheduled, because we have a sense of how far out that's running. So there are some things that you can put in place, but that's a good question, Mary. And I don't know whether Judge Schlegel is, putting that in as a recommendation for her court, or whether she's saying that's mandatory. I guess something to look at, and a good question.
And just to give a little bit more background, just because I pulled up the one that I received, but Judge Schlegel is essentially issuing a case scheduling order that requires that 14-day time period.
Right, so it's the competing. So Mary, it's the competing between one court rule and the court rule, the motion court rule, and then the court rule that allows the judge to control its case, his or her case through the scheduling order.
Yeah, I think it's interesting. Yeah, we'll see what happens with that, you know.
Well, I guess we will see.
No, I mean, I think that I do think like the 7-day rule is crazy. Like, so you can hand deliver to someone 5 pretty substantive motions and that are scheduled for a week away, and then they're expected to turn something around within a couple of days. So I think the court rule dates don't really reflect how practice is for lawyers. But I just question, can a judge like restrict, you know, like make it more restrictive? Suppose somebody had a motion, but anyway, we'll see.
Well, here's a question to sort of piggyback on that, Mary, and this is something that I have done before and have seen raised as an issue. If somebody drops all those motions on you in that short time frame, the other side might come in and say, I need some relief from this. What if we, and if they can't get the other side to agree, I've had them come to me and say, you know, this is unreasonable. And so will you, judge, will you give us some relief? And if I push it out on the back end, so I'm not mandating a different time frame for the filing up front, but I'm allowing relief on the back end and pushing the hearing out further. So that's one way it can be handled.
I think you totally can do that.
Right. So that's, you know, that's something that could be considered. One way we try to control that, Mary, as well, is of trying to avoid people trying to just drop motions as opposed to how they call and schedule. I mean, you're supposed to be calling and scheduling these motions. And so, and sometimes it's hard for us to know on the court side until you actually see the pleadings, how complicated or big of an issue it will be to have multiple motions in a short period of time like that. So sometimes that's something you just have to raise with the judge's office or the opposing party. I mean, first go to the opposing party and see if you can get an agreement, of course. But it's an interesting issue.
Judge, have you faced any other challenges over the last year or so as far as managing your docket and just keeping cases going?
Well, I mean, the obvious is obviously the criminal docket that, you know, we're just with trials being stalled, we're in not good shape, let's say, for criminal case disposition. And I think that's getting a little better. I think earlier in the pandemic, either lawyers, I think it was less lawyers, I think it was more clients, were, you know, just figuring, well, my case isn't going to come up, so I'm not going to enter into an agreement, even though I might have a good offer on the table. That is changing a bit now, but there was a lot of that early on, and that's caused a lot of additional unnecessary backup. We had cases that, you know, under any circumstance would not go to trial and would be, when an agreement would be reached on, that were not pleading in the regular pace that they would have been in terms of the life of the case. And so we've done some things, all of us across the board, to try to help move that along. And I think lawyers have also been working on that. And as I said, it has become somewhat better. We're getting more pleas than we were earlier in the pandemic. Partly, I think both sides realize that it's going to be a mess, not just for the court, but for the prosecutors, for the public defenders, for the private practitioner. defense lawyers. And so I think everybody is working hard right now to try to help that, move that along. But that's the real obvious thing, Alex. And there are other things, that as we all have been talking about, there's good and bad to this, and we'll take away the good parts, hopefully, and continue practicing with those good parts of this, and then try to get back to some normal life. I've thought a lot about the differences from the practitioner side, especially from young lawyers. I spent a lot of time hanging around courthouses and learning from lawyers who were more experienced than I did. And I don't know how you get that sort of hallway, just kind of hanging around, waiting for your case and talking with other lawyers or even lawyers of your same experience, but getting ideas. Because one thing that I'm sure many of you realize, that no matter how long you've been practicing, and no matter how experienced you are, you're still going to run into things that you have no idea about. I mean, it always amazed me in practicing, where you could be at a deposition, I could be sitting around a table with 5 or 6 of the smartest lawyers I know, and an issue would come up that no one had a clue as to how to approach it. That happened on a regular basis. One of the great things about practicing law, I thought, is that kind of constant learning and challenge. So I've often thought about what lawyers are missing by not really being here in person and watching other hearings and things like that. So it's one of the things that I think we all miss a little bit.
I've certainly thought about the brand new attorneys who have started during the pandemic, and I don't think I could do it. Because I remember going to court when I first started and basically just asking, how do I do this?
Right.
Hopefully
Right.
someone points you in the right direction.
Right. You get help from the law clerks, you get help from other lawyers, you get help from the judge. And some of that is missing. So hopefully we'll get back to that part of it at least.
I think this would probably be a good time for me to thank Madeline Lowry, too, our executive director for the Ingham County Bar, who's joining us tonight, for helping us hopefully recapture a little bit of what we used to have through these kinds of events. So thank you, Madeline. Hopefully you can hear me.
We all thank Madeline. She keeps us moving along in all kinds of ways in terms of the bar keeping together and getting educated, and in terms of professional interaction.
Thank you both very much. I appreciate it.
Thank you again, Madeline. And we're about halfway through, Judge. I was wondering if anyone from the panel has any questions, or I certainly have more, but I don't want to monopolize the whole event here.
Everybody's quiet, so I'm gonna kick out. Oh, there we
We
go.
can call on them
I
too.
have one, Your Honor, what's the biggest surprise when you became a judge that you think, boy, if I'd known that I wish I'd known that when I was a lawyer?
Oh, that's a great question. Something I wish I had known when I was a lawyer. Geez, I thought I knew everything when I was a lawyer.
Or something you wish lawyers knew, like that, we don't get paid by the word, or whatever the situation is. Sometimes if you could just tell lawyers, I wish they did blank.
Well, let me start with the hardest thing that I had to overcome in terms of, well, there are actually 2 of them. One is, I think, probably obvious, shifting from being an advocate to sitting back and letting both sides do their thing. And I try to be, again, with my philosophy of staying out of the way, I try not to interfere with what they're doing, because One of the things that I think can be frustrating as a lawyer is when the judge jumps in thinking they know what you're doing and they don't know your case as well as you do. And so I've always been mindful that you could really mess up a strategy by assuming you know what the lawyer's strategy is and what they're doing. And where I have that come up sometimes is when I see opportunities for objections or challenges from an evidentiary perspective that aren't being raised. And sometimes if I get really concerned about it, I might call the lawyers up to the bench and just make sure I'm not missing something. But there are strategies I realize that lawyers might be following that aren't obvious to me and I shouldn't get in the way of. But that shift from being an advocate, was something that I was conscious of from the beginning. So I think I towed the line fairly well, but sometimes I probably still have trouble with that. The other thing the one thing that I had a hard time just breaking as a habit was being a timekeeper type of practice that I had, being, billing by the hour. It took me a long time before I realized I didn't have to worry about how much time I was spending or keeping track of time during the day. I kept wanting to write down, I'd read somebody's brief and I wanted to be conscious about how long it took me to read it. And it took a long time to get out of my head that it didn't matter how long, other than keeping up with the workflow. It really made no difference how long it took me to read something or write something. So those were some things that were kind of things that I had to get over. But I still haven't answered your question, Mary, as to something that I wish I knew or that I could tell lawyers that they should keep in mind. I'll think about that. I'll give you an answer. I'll walk across the street and give you an answer sometime, Mary.
I know my other question was going to be, what role do great neighbors play in your life? But I figure you can just answer that later on, so, or who's your favorite neighbor? But I feel like that would be Mark Grua. So I don't want to know the answer to that.
Mary, I once heard that we shouldn't ask questions we don't know the answer to.
I know, that's why I didn't ask it, Alex. That's why I threw it out there, but said I don't want the answer.
I'm going to give you the safe answer. Your dog, Callie.
That's the best answer.
Other questions that people have? I'm going to raise a subject that maybe folks aren't thinking about, but you should be thinking about. Some of you who are on this is, we just had a whole round of new statutes that went into effect that will impact some of your practices in terms of the criminal law side. And we're all trying to get our arms around the new rules for arrests, issuing arrest warrants and probation practices, the whole body of legislation that deals with jail diversion. And I know the judges have been struggling with getting their arms around it in spite of a scale training on it. I think the probation officers are having some challenges with it, and I assume defense lawyers and prosecutors probably dealing with it. But it's something, in case you're not aware, something to, if you do any type of criminal practice, to take a look at. There are some interesting issues that are in effect currently.
Judge, what do you think is going to be the biggest impact of those reforms that are being put in place? And I would have to imagine that the changes to probation might be the biggest, but I'd be interested to hear what you think is going to be the shift.
Yeah, I think the probation changes are really pretty significant because of the limitations of taking somebody into custody, how you go about handling probation violations. I know it's going to be a challenge for us in the mental health court, where we have, we often have sudden shifts in people's mental state, essentially, that causes them to go off course really rapidly, and you want to get to them really rapidly. So things like waiting until somebody has absconded for 60 days doesn't work real well for us. So there are a lot of things in, sanctions and things like that we put in place that are pretty significantly changed by the new probation rules. And so there are some things that I think you're right. I think probation is going to be a big challenge. There are a lot of good parts to it, and a lot of things, obviously a lot of circumstances where folks should not be incarcerated and are more quickly incarcerated than they probably should be. So those are, good things that are being put in place, but the implementation is going to be interesting, and I'll be watching for for you appellate lawyers, I'll be watching for some of the appellate case law on it, the requirements for tailoring probation conditions to the individual. There's, some of that obviously goes on and has been part of the practice of probation already. But the making of the record of that, it seems more and more, there are more rules going into place since I've been on, just in the time I've been on the bench, a lot more rules have gone into place about things that have to be part of the record. For example, one of the things under the new probation rule is advising defendants of their early discharge rights. Well, the early discharge statute now is really pretty long, and there are a lot of parts to it. And to advise of the rights, it's sort of hard to know what exactly do you say that is actually meaningful to a defendant who's, if they're standing there and you're running, 15 different sets of advice of rights by them, what is actually meaningful and is helpful to them. I'm putting some written advice of rights about that in my sentencing orders, but we'll see, what the appellate courts say that you need to do in order to comply with that.
Thank you, Judge.
So a lot of challenges there.
You mentioned mental health court just a minute ago. For the non-criminal practitioners, I was wondering if you could explain a little bit about what mental health court is, what your role in it is, and how have things changed over last year?
Well, mental health court, for those of you not familiar with it, is I sort of have viewed it as a hyper-intensive form of probation that does a couple of things in terms of it being a more aggressive form of probation. Is number one, it provides funding that for certain types of support services that we might not have in regular probation. It provides a lot more frequent, a lot more contact between the probationer and the judge, the probation officer, and the team. It's a setup of it's a team approach. It's a treatment court. And one of the things that is hard to sort of understand if you're not too familiar with this type of a treatment court is it's an incentive-based court as opposed to a sanction-based court. Not that there aren't sanctions, but that is one of the big distinctions between the mental health court and some other types of problem-solving courts, is that it's not designed to be sanction-based like Swift and Sure Sanctions is a sanction-based type of a program. And for us, it's a felony level program. I was involved with a lot of other people in getting it going, including Judge McCormick, who was incredibly instrumental in terms of us having this court in this county. I'm pretty certain that we would not have had it had Judge McCormick not been on board and hands-on from the beginning of the court through her tenure in the prosecutor's office. And we started it, I don't know, 14, I guess, was the first regular year. We had a pilot program initially, a planning grant. And it is designed in the format, as I said, of a treatment team. The participants on the treatment team are folks from community mental health, a dedicated probation officer, so that everyone in the treatment court has the same probation officer as everyone else in the treatment court. That's Boyd Myers is our currently assigned dedicated probation officer. It has a prosecutor's office representative and a defense representative. Aaron Schroeder from the public defender's office is the dedicated defense lawyer. Now, when we started, we had, before the public defender's office, we had a group of folks from the defense appointed list that volunteered with us. But now we have one dedicated lawyer. And so we meet as a team and make decisions. And then every week, when you're new in the program, it's a 3-phase program. In your first phase of the program, you see the judge every week. And then that, as you progress to the next phase, that goes down to every other week, and then goes down further when you're in the third phase. And there are milestones or markers that you need to meet in order to advance through the program from phase to phase, and then eventually graduate. And the idea is to provide supports that would be harder to get through regular probation. Everything from mental health treatment supports, counseling, and help with psychiatric services, and making sure you're taking medications if you're on medications, to community supports. We have some really tremendous community support services, including Northwest Initiative, which is a day program run by a lady by the name of Monica Janner. And we can send folks there to get help with everything from GED programming and testing, to helping you find a job, helping you with prepare resumes, helping you find housing. We have lots of treatment partners to help with different types of addictions, because as many of you probably realize, most of the people who are in our program who have a serious and persistent mental illness also have a co-occurring substance use disorder issue. And so we do a lot of we try to do a lot of dual support and treatment. So it's, it's a very intensive form of probation with a lot of support services and a lot of access. Folks can call the probation officer really anytime. They call them during the night, they call on the weekends. I get emails all hours of the night and weekend about, what do we do under this service or this emergency, and how can we get somebody services if we have to get them into crisis services at community mental health. And currently, the way it's operating is going back a couple of years. I had some personal reasons for stepping back a bit from the court, and we had some interim folks do the review hearings with the participants, and eventually that evolved to Judge Buchanan doing that on a regular basis. And so she's still doing most of the review hearings, and shifted to a Zoom format to do those, which isn't ideal with this particular population, but it's been working out. And I handle all of the things that need to be handled here in court, like probation violation hearings. I do all the sentencings and probation violation hearings. I participate with the team when the team meets, and then Judge Buchanan's been doing for the most part, been doing the review hearings, the weekly review hearings. So the big shift has been, like everything else, to Zoom for the participant review hearings.
Thank you, Judge. And we're getting a little close to the end of our time here. I was wondering if anyone else has some questions, or I can keep going too. Or I can have Judge call on people. Well, maybe one of the thing that I've been interested in, Judge, and if anyone has a question, feel free to just interrupt me. But have you had to do any Zoom trials? And if you haven't, do you think you would ever want to do one?
I have not done any Zoom trials. I know Judge McCormick has. They've had to do more on the second floor. I have not done a Zoom trial. As you probably know, Alex, there have been a couple of attempts to try different things. Judge Aquilina has, picked juries a couple of times on Zoom and then moved the trial into the court. There's been some talk about doing a full-blown Zoom trial, jury trial. I'm not quite sure how you do that. I think it presents a lot of challenges. I've had some evidentiary hearings, Zoom evidentiary hearings with, exhibits and things like that, but not a Zoom trial. I haven't even done a Zoom bench trial, although I'd be happy to do that. That would be, fairly easy to do. Judge McCormick might want to jump in. She has done some Zoom trials.
I don't want to take away from you, Judge James.
No, but go ahead.
But I have done Zoom trials, obviously, and the neglect and abuse. We've been able to move those cases with doing Zoom trials. There's pluses and negatives, certainly. But for the most part, in Ingham County, the courthouse has been open except for this latest phase 1. So people have been able to come in, and you can still come in if there's a statutory requirement for someone to be there. So it doesn't mean you have to use Zoom. We've been doing hybrid trials where someone's in the courtroom and someone's on Zoom. And I think that we've just learned to be a little flexible and try to deal with the technology problems as they come, and just do the best we can under the circumstances. But I don't think there's anything that it's sometimes a little bit more difficult with the exhibits and things of that nature, more those types of evidence issues. But other than that, we're able to move the cases along.
Yeah, and that's what the exhibits is, that's a good point that Judge McCormick brings up, because that's where I've seen in the evidentiary hearings I've had, it's a little awkward. I think I can't remember if it was my assigned assistant prosecutor, Jen Lawton Pace, or somebody, the first time we did an evidentiary thing, the lawyer, I can't remember, I don't mean to call you out, Jen, if it was you, I can't remember for sure who it was. But just like we normally would do, said, the witness was on Zoom, of course, and said, I'm going to hand you, whatever exhibit. Oh, no, I guess I can't hand you the exhibit. It's just because that's our habit. And so, we've had to talk about getting things marked, getting them to, my court reporter's not here. So getting them emailed to my court reporter so that she can keep the exhibit for the record, and then making sure everybody has them, and then screen sharing or making sure that, there's a way to show it to the witness, and then go from there. So there are ways, like Judge McCormick said, these things come up, but people figure out how to get through them. There's a way to do it. So sorry, Jen, if that was you. I can't remember whether that was you, but it was just sort of a funny moment because none of us had really been thinking about, well, you can't actually pass the exhibit around in court any longer. And I'm sure a lot of you are experiencing that in, depositions, making sure that was always, for those of us who took a lot of depositions, like in civil litigation, we always had some remote depositions, somebody's across the country somewhere. And so we dealt with that to some extent before in terms of shipping exhibits out and making sure they were available to everybody. So this is, just kind of shifting that into a more frequent, more common practice.
Do you expect to continue to keep using Zoom for evidentiary hearings as we kind of progress through the year here and into 2022?
Yeah, I do. I'm probably on our bench, maybe the slowest in terms of being anxious to get back in the courtroom. I'm in the courtroom. I actually do my hearings in the courtroom. But in terms of bringing a lot of people into the courtroom, as Judge McCormick said, it's possible. And for their hearings, there's oftentimes more reason for people to be in person in the courtroom for a lot of the types of hearings that are happening in the, in the family division. So I expect to, for quite some time now, have routine hearings still remotely, having them on Zoom. It'll be interesting to see what happens when we open up and start having jury trials. I hope that's sooner rather than later in terms of just being able to move cases forward for folks that, everybody needs to be able to move forward with their cases. But I've been thinking a lot, Alex, about what to do once it's safe for people to be back in the courtroom on a regular basis, how to efficiently adopt parts of what we've learned and keep that going, and and have sort of a blend. I kind of foresee a blend of in-person and remote, but thinking about my law practice and trying to think about what happens if a bunch of courts are doing a bunch of different things, how that's going to work. Like if I tell you that you're going to have a hearing at this time, but it's going to be remote, and somebody else, even two doors down says, we want you in the courtroom for your hearing. What do we do at that point? Do I say, okay, well, since you're going to be next door, forget about the idea of doing a remote, or are we going to do a blended thing because you're here and the other lawyer is in Detroit, they want to be remote? Are you okay, or are they okay if you're in person but they're not? so it's going to present some challenges as to how to do it. Or if you have a bunch of remote hearings, and so it's better for you to be at your office so you can knock down a bunch of those in a row, but then you have one judge who says, no, you have to be in person. How do you handle that? Especially if you don't have a lot of lawyers to send to different parts of the state. So it's going to require some planning and scheduling issues. I'm sort of wondering how some of the firms have been planning, some of the larger firms in particular, planning staffing going forward. Like, how many lawyers do you hire after, having summer interns or something? Are you going to need as many lawyers if you're doing more remote work? And I don't know, some of that seems mind-boggling to me from a practice management perspective. And I think we're going to have to try to manage it from the court side.
Yeah, I certainly think there's a lot of great things we can adopt and a lot of challenges going forward.
Yeah. I think we're up to the task, though.
We have no other choice.
Exactly.
Judge, that brings us right to 6:30 on the dot here.
Okay.
Thank you very much. I know I appreciate your time. Do you have any closing remarks or anything you think we should be left with?
I don't. I mean, hopefully we'll all soon be getting together and, doing things like the shrimp dinner in person and the, bench bar conference and the meet the judges and get back to that, some of that personal interaction that, we have such a great local bar. I've always said that. I tell people, when I would travel around the state, people would, complain about the practice of law and professionalism. I'd say, come to Ingham County. We have a really great local bar and, get together a lot and do a lot of good things. So hopefully we can get back to that.
Thank you, Judge. I feel the same way. And we do have a couple more opportunities for this series and then also our shrimp dinner alternative this year. So coming up on May 10th, we have Judge Kennedy doing another Keeping the Bench and Bar Together forum. On May 24th, we have Judge Aquilina. I believe that's going to have very much a criminal law focus. And then Judge Stokes is going to be having her forum on June 14th. And of course, we won't be enjoying shrimp this year, but May 12th, 5:30, Chris Wickman, who's been helping us run this entire presentation today, he's going to be giving us a little demonstration in place of that shrimp dinner. And we'll also be announcing the winners of the ICBA Board of Directors election. So I encourage everyone, it's not the same event, but I'm hoping it's going to be a great one anyways, another opportunity to get together and stay connected. So,
Well, looking forward to that.
well, thank you everyone for attending. No need to stay around.
Thank you.